Good evening. Welcome to our company law class. So last time we met, we're discussing forms of business organizations. We look at the various models of vehicles that are available for conducting business. So we're about to discuss incorporated company. So because we reach incorporated company, we would like to move straight to start discussing incorporated company by looking at the law itself. So what I usually do is that we be discussing the law as and when I need to veer off into a bit more theoretical discussion and maybe give you some slides, then we do that. So that is how we are proceeding. So incorporated company is a company which has been formed and registered in accordance with provisions of the Companies Act 2019 Act 992. It also includes companies that were registered under the repealed Companies Code or Companies Act 1963 at 179. So let us keep in mind. And that is why, if you look at the most important legal framework which governs incorporated company, the long title will tell us that it's an act to amend and consolidate the law relating to companies, to establish the Office of Registrar of Companies, and to provide for related matters. So until 2019, we had our main company legislation called the Act 179. Act 179 had seen various amendments, piecemeal amendments here and there. So the lawmaker considered it a bit untidy. So the lawmakers in their wisdom decided to bring all the scattered amendments together. So you call that consolidation. So they were all consolidated. And of course, new things have also been added. So as you notice, the act is also focusing on establishment of the Office of Registrar of Companies. And the Registrar of Companies is being decoupled from what used to be known as Registrar General Department. So previously, the Registrar General Department or the Registrar General was wearing many hats, serving as the Registrar of Companies, serving as the Trustee General, serving as the office responsible for trademarks, patent registration, and so on and so forth. But now, under the new law, we have a standalone office known as the Registrar of Companies, Office of Registrar of Companies, which is responsible for all matters relating to formation, relating to governance of incorporated companies. So let us keep that in mind. Now, in terms of the scope of application of the new law, Act 992, Section 1 makes it clear that it applies to companies formed in Ghana, that is the Republic, whether before or after commencement of this act. So all companies formed under the old law are still subject to the operation of this particular new law. So let us keep that in mind. And that is why Section 1, Subsection 2 has made provision, what we call like a saving provision, which says that this act does not affect validity of anything done before the date when the act comes into operation. So here, before the act came into operation in 2019, as we have stated already, there were other legislation, including like the main Act 179 in force, and various steps will have been taken with respect to existing companies. Now, the new law is saying that all those things which were done under the old law or legal arrangement are still valid, notwithstanding the fact that those laws have ceased to exist. So let's keep that in mind. Another preliminary point worth taking note of is the fact that there are certain aspects of the Companies Act, and you've made that point already when we're discussing the introduction to company law. There are certain provisions of the Companies Act, Act 992, which are applicable to only particular types or category of companies and not others. So for example, if you look at Chapter 2, it is considered as a general framework applicable to all companies regardless of the type. Chapter 3 applies to only companies which are designated as private companies. Chapter 4 applies to public companies. Chapter 5 applies to external and non-Ghanaian companies. So let's keep that in mind as we move along. Now, when we're discussing partnership under Incorporated Private Partnership Act at 152, we came across the point that a partnership should not be more than 20, and it should also not be less than 2. So certainly you cannot have a one-member partnership that is conceptually flawed, or that is impossible. And again, you can also not have partnership of having 20 or more, more than 20 members. But in the case of incorporated company, you can have even a one-member company. You can have as many people as possible constituting the membership. So just for avoidance of doubt, Section 3 tells us that if you have a company or an association of more than 20 persons, then that cannot be formed for purpose of carrying on business that has for the object acquisition of gain by the company or the association, unless the company is registered as a company under this act or is formed in pursuance of any other enactment. So what Section 3 is trying to do is that if 20 or more people come together for purpose of running a business and making a profit, you are not permitted to use incorporated private partnership vehicle. You are supposed to use incorporated company vehicle. So that is the point about Section 3, and that is why it is prohibiting association exceeding 20 members for purposes of making profit. If that is so, incorporate as a company. So that is the point about that. Again, we have also noted that Section 4 recognizes the fact that there are certain special companies which are subject to special regulation. And that is important because we have banks, we have insurance companies, and some other special companies, as you know. So for those companies, they have their own regulatory framework. So if you take like bank, for example, you want to set up a bank, you need a license to operate as a bank, and the license will have to be obtained from Bank of Ghana in accordance with the Banking and Other Special Deposit-Taking Act. Now, when you go to that legislation, you'll be told that you will not be given a license unless you are registered or incorporated as a company. So you need to get the vehicle called the incorporated company or the company before you can go to the regulator, let's say Bank of Ghana, and apply for the license to set up and operate banking business. Similarly, If you want to set up insurance company, you need the insurance license to run insurance business. You need to get it from the National Insurance Commission. And they will require that you have a company. And that is why Section 4 says that this act does not abrogate or affect legislation relating to companies carrying on the business of banking, insurance, or any other business, which is subject to special regulation. In other words, the Companies Act, by requiring certain things to be done, does not mean that those companies will not have to satisfy requirements of the special regulator under which their company falls, such as banks or insurance, as the case may be. So let's keep that in mind. And for banks, for example, you come across this situation where, for example, when it comes to debentures, right, creating a charge and all that, the Companies Act provides that, yes, to have a floating charge or a fixed charge, the particulars will have to be registered in accordance with the Companies Act. But then, if you go to the banks, they have, for example, Lenders and Borrowers Act, or previously even like the Mortgages Act. And those legislation may be saying something which actually do not require, if you like, compliance with what the Companies Act is saying. So when you have a scenario like that, how do you navigate? How do you resolve it? And that is why Section 4 is saying that, yes, those legislation are still effective. And where you have like we talk about this point already when we're discussing the general introduction, then where you have like a seeming contradiction, then since those legislation are specific legislation according to the specialibus non-legibus degregate principle would always supersede the general legislation. So if you have like a general legislation and specific legislation, the specific legislation is deemed to be holding sway over the general legislation. Another point we have noted already is that, yes, the Companies Act has made various statutory provisions. That notwithstanding, there are certain principles which have developed at common law through judge-made law, and those are still considered as part of our company law. So that is what Section 5 seeks to do. So these are just preliminary matters that we needed to keep in mind. But just before we move on, we would like to look at the various types of companies. We'd like to look at various types of companies, and having looked at the various types of companies, we will discuss the procedure for registration of companies as it were. So, but just because we are going in a linear order, Section 6 enshrines the right to form a company, and it's to the effect that a company may be formed by only one or more persons. Now look at it. It said may form an incorporated company, not just a company, an incorporated company. So a company which has been registered in accordance with the legal framework of Act 992. So let us keep that in mind. So what are the various types of companies that are permissible under our law? Section 7, subsection 1 is instructive on the various types of the companies that we may have. I said section 9 because if you look at the old legislation, NILM and company law under the old legislation at 179, section 9 used to be the provision on types of companies, but that has changed. Now the types of companies are governed by section 7. And according to section 7, an incorporated company may be a company limited by shares, limited by guarantee, unlimited company, or an external company. So we'll explain them one after the other. So that is one way of classifying companies in terms of the type of the liability, and also in terms of, if you like, nationality. So from A to C, we are talking about, we are classifying the company in terms of the type of liability. So if liability is based upon number of shares, there's a company limited by shares. If liability is based upon the guarantee which a person has made, then that's company limited by guarantee. And then if the liability is not capped by anything, then it is unlimited company. On the other hand, the nationality of the company is also another of classifying. So on that note, we have, if you like, national or local companies and external company. So A to C, they are all, if you like, national or domestic companies because they have Ghana as their place of incorporation. And for that matter, they are Ghanaian companies. But Section 7(1)(d) contemplates the possibility of having companies registered in other countries or jurisdictions wanting to do business in Ghana or have a place of business in Ghana. So those companies are known as external companies. External companies. So let us explain each of these types of companies one after the other. So when we say a company is limited by shares, what does it mean? Section 7(2)(a) makes the point that a company limited by shares is a company which has the liability of its members limited to the amount unpaid on the shares respectively held by them. What does that mean? That is to say that in a company limited by shares, the members have shares, and the members are supposed to pay for the value of the shares, okay? Now, if things become rough, things become difficult, and the company is, for example, insolvent and is being liquidated, and the company has got debts and liabilities, in terms of allocation, apportionment of the debts or the liabilities, each shareholder will contribute only the amount of money he or she paid or is supposed to have paid for the shares and no more. In other words, if you had 100 shares in the company, and let's say that the 100 shares were worth 1,000 Ghana cedis, and let's suppose that you have fully paid for those 100 shares, you paid 1,000 Ghana cedis, and the company becomes insolvent, the company is being closed down, is being liquidated. There are debts. Now, you as a shareholder with 100 shares and having paid the full value, that's 1,000 Ghana cedis, all that you stand to lose will be the 1,000 Ghana cedis that you paid because the company is owing and there will be no surplus for you to get your money back. Beyond that, no one can call upon you to come and pay anything towards the outstanding debt of the company. In a similar vein, where you had 100 shares and you have paid for, let's say for the value of half of the shares, okay? So let's say that you pay 500 Ghana just for illustration. And the other 50, which is also worth 500, is unpaid. And in the course of time, the company is being liquidated. It's become insolvent. It cannot pay its debt and liability, so the house will be closed down. Now, when it gets to that stage, and a liquidator, an official is provided to preside over the closing down of the company and payment of creditors of the company, you as a shareholder who had paid for only half of the value of the shares that have been issued to you, you'll be called upon to come and contribute towards the debt and liability of the company. But all that you contribute is the unpaid value. That is the remaining 500 cedis which you have not paid. When you pay the remaining value and there is still more debt left to be paid, nobody can ask you to pay even an extra peso or extra cent or extra penny, as the case may be. And that is what economy limited by shares means. So that your liability is limited to the amount unpaid on the shares. So the example that I use, the shareholder having 100 shares and having paid for only half of the value of the shares, if there is liquidation, all that the person will lose will be the unpaid half, which is like the 500 Ghana cedis. And once that is paid, that is all. Nobody can ask the shareholder to contribute any other amount of money. So let us keep that in mind. Before I move on, is there any question on that? If you have a question, just raise up your hand quickly. Any question? Okay, Ima, you can unmute. Emmanuel, yes?
Hello, my lord. Good evening.
Good evening.
Something is battering with my mind, and I want to.
Yes, please go ahead.
So let's say if you are a shareholder in a company, maybe you have 100 shares in the company, and you pay, let's say, 500 Ghana cedi, and left with 500, and the company is liquidated. So it means that you have to pay the additional 500. After paying the additional 500, no one will ask you to pay any other money apart from the 500 Ghana cedis.
That's correct. That's correct. And even the
Okay.
500 that the 500 you are being asked to pay is because you haven't paid it. If you had paid for the full value of the shares, and if there were debts, nobody can ask you to come and contribute even a peso.
Oh, okay. Okay.
Yes.
So it means if you have paid all the 100, no one will
Yes.
ask you to come and pay even a peso.
Yes, that is
Okay.
it.
Thank you very much, my
Very
lord.
well.
Thank you very much, my lord.
Then yes, Akonoba. Akonoba, you can mute. Akonoba, your hand is up. Unmute and talk. Akonoba, please go ahead. Oh, was it a mistake? Okay, let me lower your hand. Evans.
My lord, good evening.
Good evening.
So my question is, I have two questions. One has to do with, does it happen that somebody may have 100 shares in an organization or a company, and he has paid for only 50? What happens to the remaining shares? Do we say that the person is having 100 shares or 50 shares based on the payment that he has done or he has made.
Okay, all right, good. Now, when it comes to issue of shares or allotment of shares, it is an agreement between the company and the shareholder. So the terms will be spelled out, and the terms definitely include how much money should the shareholder pay? What are the modalities for payment? Is the shareholder supposed to pay the full value upfront, or the shareholder is permitted to pay only a portion? And then the company will say that as and when we need money, we will serve a call on you or we make a demand on you to come and pay. So it all depends upon the terms of the issue, the agreement which the company entered into with the shareholder at the time of issuing or giving out the shares. So if the understanding was that pay part, maybe pay 60% of the value of the shares we are giving you, the remaining 40% we will call upon you as and when we need it. Then, to all intents and purposes, if, for example, the shares given to the person were 100 shares, despite the fact that under the terms of the issue, he or she paid for only 60%, he will still be regarded as being 100%, if you like 100 shares holder, or being a shareholder in respect of 100 shares. But where the company has served a demand on you to come and pay, you ignore the demand, you don't pay, the company may exercise the right of forfeiture, that is cancellation of the shares, the portions that you haven't paid, as it were. So that is how it is. Okay, let's say the last question, then we'll move on. Edward. Edward.
Yes, good evening, my lord.
Good evening.
Yes, my question has to do with the sole proprietorship. This particular session talks about the companies limited by share, guarantee, unlimited, and external. What comes of the sole proprietorship, my lord?
Sole proprietorship is not a company. Sole proprietorship simply means a one-man or one-woman business where you are doing a business and you have not registered the business itself so that the business will assume a legal personality. In the eyes of the law, the business will be treated as separate and distinct from you, the business person. Now, when you have not done that, you are just doing your business, that is where we say that you are a sole proprietor or you're a one-man business or one-woman business. So there's no question of shares. I don't know if that is clear. So when we're talking about sole proprietorship, it doesn't feature in incorporated company because it's not a company. Evans.
My lord, my second question.
Okay.
Has to do with some companies are registered under the Department of Corporate, and members pay shares. Is Act 2019 applicable to such companies?
Please, I repeat your question.
Okay, so I'm saying that some companies are registered under the Department of Corporate.
Right.
And members are allowed to pay shares.
Okay.
In the company. Is Act 2019 applicable to them?
Okay, that's a good question. We have the cooperative companies, cooperative societies or cooperatives, yes, acts, which said allowed credit union and all that to be set up. Now, there was a decree which was passed, and if you look at the slides I gave you on business organizations, they are there. There's a decree which was passed by the SMC government, the Supreme Military Council government, and then the National Redemption Council government, which encourage people to come together, pool their resources together. Maybe like those in Apatashi Distillery, you come together, you form a society, and you make some, savings, and out of that, loans are given to members at relatively low rates and so on. But then, to ensure that there's a capital, shares are created, and they are supposed to have shares as well. Interestingly, if we look at how that legislation is, one will argue that when the lawmaker made it, the lawmaker was aware of the pre-existing companies code at 179, because at 179 is 1963 legislation. And this thing we are talking about is in the, what do you call it, the 70s, when head of state, a champion, was in power and all that. So it is also a special legislation, and it will come under Section 4. If you remember Section 4 that we just look at it again. Section 4 says that this act does not abrogate or affect legislation relating to companies carrying on the business of banking, insurance, or any other business which is subject to special regulation. So a legitimate argument can be made that a cooperative union or cooperative society or credit union and so on is a company or is a special company, and it has its own special legislation. Where there's a inconsistency or there's a contradiction or conflict between the cooperative act or legislation and the Companies Act, then the cooperative will supersede the Companies Act in relation to the cooperative society or the credit union, because of the legal principle that if you have like a specific legislation on a subject matter, then that will supersede the general provision on the same subject matter. Evans, so that is how it is. Okay. Evans, I hope that assists you. Akonoba, your hand is up. I ask you to continue to Akonoba. Yes.
Thank you very much. I'm
Yes.
sorry it was my network, especially. My Lord, please, when you were explaining the share amount, you
Yes.
said when the shareholder or when those who register the company, when they pay that amount, that is it. Can there be a situation respectfully whereby in the course of the business, the shareholders can sign a binding agreement on them? For instance, maybe putting a
Please, where I live is a flight path. Almost every 20 minutes, an airplane passes over. So sometimes the noise drowns the talking. So can you repeat? Hello? You also have a network problem, sorry. Hello, Akonoba? Well, if the network is not helping, you can use the chat. Okay, I'll look at it later on, but let's continue. Good, so we have finished explaining what a company limited by shares means, and I hope all of you have understood it. We also have a company limited by guarantee. Company limited by guarantee. A company limited by guarantee, according to section 7, subsection 2B, is a company which has the liability of its members limited to an amount that members may respectively undertake to contribute to the assets of the company in the event of it being wound up. So let's pay attention. In a company limited by guarantee, at the commencement or at the time of registering the company, the members will make undertaking in the form of guarantee saying that should things go bad and the company is in debt and the company is being forced out of existence because of its indebtedness and all that, it's been liquidated. Okay, I am prepared to contribute this amount of money towards settlement of the debts of the company. So it's like a solemn, if you like, promise, so to speak. Which you have made regarding how much money you are prepared to contribute towards meeting the debts of the company. And when you have made such a guarantee, and should debt actually come and the company is being liquidated or forced out of existence because of its indebtedness, you as a member of company limited by guarantee will be called upon to pay the exact amount which you undertook to contribute. And after contributing that, if there are still unpaid debts, nobody can force you to contribute even the peso because your liability is limited to the guarantee that you made, the undertaking that you made to contribute a particular amount of money, so to speak, towards meeting debts of the company. Let me see if the person has put the question in there. Okay, somebody has brought up a question. My Lord, with the saving clause by section 5, it means incorporated company can enter their own dealings that existed before this act. If so, it means irrespective of any provision of this act, everything becomes binding between them. I don't know if I've understood your question. If your question is that if companies had agreement or some arrangements before the coming into force of Act 992 in 2019, will that agreement be binding, despite the fact that it's not in accordance with the provisions of Act 992? Well, as we rightly read from section 5 that you have already quoted, all arrangements which were made under the old legal regime before Act 992 came into force are considered valid and binding. Yeah, so that is the point. Okay, let's continue. We also have unlimited company. Unlimited company. Unlimited company does not have a limit on the liability of its members, meaning that the liability of members of an unlimited company is just like the sole proprietorship, so to speak, and then probably also like the incorporated partnership. Yeah, so one may ask, why would anybody form unlimited company? Why will anybody form a limited company if there is no limit on liability? Now, if you look at professions, right, such as maybe lawyers, barristers, or accountants, instead of sometimes registering an incorporated private partnership, they incorporate what we call unlimited liability company. Of course, because you are providing a service, that is usually like the requirement by, let's say, your regulator. And it also goes to ensure that unless we take a insurance policy, your own assets may be up for attachment in the event that people that you serve sue you for professional negligence or for some other legal action. But then, when you have unlimited company, you also have a bit of like a peace of mind in terms of reporting requirements. Because in terms of various disclosures, reporting requirements, and all that, you are not overstretched like having a company limited by shares or limited by guarantee, as the case may be. So let us keep that in mind. Now, apart from classifying company by type of liability, as whether it is guarantee, whether it's by shares, or whether it's unlimited, you may also classify a company according to size of membership. So therefore, Section 7, subsection 4 provide that a company which is limited by shares or by guarantee, or even unlimited, so to speak, may be a private company or a public company. So you can have company limited by shares, which is private or public. And the same thing applies to limited by guarantee. So what are the defining characteristics, or what sets a private company apart from a public company? Now, if we look at Section 7, subsection 5, we are told that a private company, other than a company limited by guarantee, is a company which, by virtue of its constitution, reflects the following. So we are going to talk about, let's say, 4 salient features which one may identify in a private company. But before we look at those features, I would like you to appreciate just a minute, I think. So let me release it. It's not coming. The content is back. Screen. Yeah. So I was making the point that a private company exhibits certain characteristics or features which are not present in public company, and vice versa. However, we need to remember that as to whether a company is a private company, and for that matter, is exhibiting the characteristics we are going to look at, its constitution must say so. And that is why 7.5 says that a private company, other than company limited by guarantee, is a company which by virtue of its constitution, so by virtue of its constitution, so if you take the constitutional document of the company, it must state categorically that it is a private company. And because it's a private company, there'll be restrict the right to transfer the shares of the company, if any. So there'll be a restriction on transfer of shares, meaning that if you are a shareholder, in a company which is private, you cannot give your share to another person or transfer your share to another person at will. You can't just do that. It's unlike public companies. If you're a shareholder in any public company, you can even advertise if anybody is interested in buying your shares. If somebody comes forward, you can even negotiate the price, as it were, with the person. You take your money, and all that you have to do is to notify the company so that the company will register the new person as the new holder of those shares. And if certificate will have to be issued, then the certificate is issued, and that's it. So that's a public company. But for private company, it is not that simple. If you want to transfer your shares, you cannot just do it. If it is even possible at all, it may even require you getting approval of the company, so to speak. And the reason is that private company is relatively small company. And oftentimes it's either a family or close business, and you don't want to open it up for just anybody at all from anywhere just to come in. And so existing members or shareholders may be interested in having a say in who joins them. Not that any single shareholder can just decide that I want to offload my shares to just anybody at all. No. So there's a restriction on the right to transfer shares. 2, or B, it limits the total number of members and debenture holders to 50. So the total number of members of a private company does not exceed 50. Of course, this 50, when we are reckoning it, certain members who may have shares in the company are not included in this 50. So that is to say that we can have those members plus the 50 we are talking about. And who are those who are not reckoned? Persons who are generally in employment of the company. So if you have workers, employees, who are be given shares in a private company, when we are trying to find out whether the maximum membership of the company, which is 50, has been attained, we will not count the employees that have been given shares. Yes, they are shareholders, all right, but the law says that they are excluded in trying to find out whether the membership of 50 has been attained. So let's keep that in mind. In the same vein, persons who haven't been formally in the employment of the company were while in that employment and have continued after the termination of that employment to be members or debenture holders of the company. So if you were given shares or you were given a debenture is just like a long-term debt which the company owes you, and then the company pays interest to you and so on. Now, if you were a shareholder or debenture at the time that you were in the employment of the company, and you got the shares or the debenture by reason of the employment, and you continue to hold on to your shares, then when we are doing a census to find out whether the company has met the maximum membership of 50, you too will be excluded from that, from the 50. Another feature is that a private company, by its constitution, prohibits the company from making an invitation to the public to acquire shares or debentures of the company. Now, when we say invitation to the public, we are talking about the possibility of going to open markets and say that, yes, we're interested in getting more money for our operations. If you are interested and you want to invest in our company, come and take shares or come and be a creditor of the company by taking debentures. You can even advertise and all that. Not too long ago, you remember MTN? I think about 5 or 7 years ago, MTN decided to do IPO, initial public offering, and they put together their prospectus, comprehensive document, saying all nice things about the company, the operations, the prospects, and all that. And they ran various advertisement commercials to entice members of the public who were interested in acquiring shares to come and put their money in the company. So that is an example of invitation to the public. However, according to the law, if you are dealing with a company which is a private company, then the law says that a private company cannot make invitation to the public. So a private company is prohibited from making invitation to the public. So let us take note of that. Then the fourth feature is that a private company is also prohibited from making invitation to the public to deposit money for fixed periods or payable at call, whether bearing or not bearing interest. So a private company cannot do that. And in fact, if we take this particular requirement, I would say that in Ghana, for many years, we're not all following the law, especially when you go to the rural banking industry. Because a bank will definitely let people deposit money. A bank will take fixed deposits and all that. Interest is given. So it is caught by this particular provision. But you notice that for a long time, many rural banks were private companies. It's just the last 2-3 years that the Registrar of Companies and then the Bank of Ghana pressurized them to align with the requirements of Act 992. But if you look at 179, If you look at 179, this particular provision is not new. We had the equivalent provision in section 9 of the repeal at 179. So one begins to wonder, while rural banks or other financial institutions were using the private company vehicle to do their business, when the law says that there's a prohibition on a private company from making an invitation to the public to deposit money for face periods, to payable at call, whether bearing or not bearing interest. Thankfully, now everything has changed. If you're a bank or if you're a financial institution, you're supposed to register as a public company, as a PLC. And then another point to note is that in making the determination as to whether the maximum number of 50 membership has been met, you may also have what they call the joint ownership of shares or debentures. It is permissible for 2 or more people to own shares. So for example, your father or your mother was a shareholder in a company. He or she made a will, giving the shares to the children or to some other beneficiaries. So the person dies, letters of administration is taken or probate is taken, and vesting assent is made. And the beneficiaries will say that, okay, we don't need to split the shares. So let it remain as it is. And we can appoint one of us to be like the trustee for all of us. Or all of us, we are going to be like the co-shareholders, as it were. So that is the kind of the joint ownership which is being talked about. And section 7.6 is saying that where you have joint ownership, then for purposes of making a determination as whether the maximum membership of 50 has been attained, we are going to count the joint owners as one. I mean, if you are 100, you'll be counted as one. So let us keep that in mind. Now, after telling us about what a private company is by virtue of its constitution along the lines that we have just explored, section 7.7 will tell us that a company which is not a private company is a public company, except a company limited by guarantee which has a membership of 50 or less. In other words, if you don't meet or you don't check all the boxes you have seen applying to private company, then you are a public company. The only exception is company limited by guarantee, meaning that if you have a company limited by guarantee and the membership is even 50 or less, it is still not a private company. And again, when we're discussing company limited by guarantee, company limited by shares, we talk about unlimited company. Unlimited company can still have shares. So mind you, the fact that it is unlimited company doesn't mean that it cannot have shares. It can have shares. And that is what section 7.3 says. A company limited by shares and an unlimited company shall, for purpose of incorporation, be registered with shares. So unlimited company, yes, they have to register with shares, except that in terms of liability, the liability is not capped by the shares which are held. But for a company limited by guarantee, section 7.8 says that it must not be registered with shares and cannot create shares or issue shares. So company limited by guarantee is not registered with shares and cannot create shares. So let's take note of that. So let's explore more the nature or the incidence of company limited by guarantee. What is it? What really is a company limited by guarantee? In terms of Section 8, a company limited by guarantee is incorporated with the object of carrying on business for purpose of making profits other than making profit for furtherance of its objects. In other words, a company limited by guarantee is not supposed to make profit for sharing among the members. If they want to make a no profit for sharing among the members, then they must register a company limited by shares so that dividends will be declared and the members will get returns on their shares. A company limited by guarantee can undertake profit-making ventures or business, but the profit so made should be in furtherance of the objects or the objectives or the purposes for which the company limited by guarantee is formed. So therefore, if you have, let's say that a company limited by guarantee for advancing knowledge in Ghanaian history, okay, you can still engage in profit-making ventures. You can make money, but the money that you are making should not be for sharing among the members, should be for promoting, let's say, knowledge in Ghanaian history, so to speak. So if profit is made by a company limited by guarantee, the profit should be for the advancement, should be for carrying forward the what do you call it, the particular object or the purpose for which the company is set up. So let us keep that in mind. And for that matter, where a company limited by guarantee, for example, they carry on profit-making business and not for furtherance of the objects, but for maybe enabling the members to share the profit and all that. All officers of the company who are cognizant, who are aware of such a situation, will be punished by the law. So later on, when we are discussing the theory of incorporation, and we are discussing lifting the veil and piercing the veil, you will cite Section 8, subsection 2, for example, as an example of an instance in which the corporate veil will be lifted, so that we may want to find out specific individuals who have done wrong thing in the company and hold them accountable or sanctioning them. Now, 8.3 re-emphasize the point that we made, that the total liability of members of a company limited by guarantee to contribute to the assets of the company in the event of the company being wound up shall not at any time be less than the amount of money specified in the application required for incorporation. In other words, at the time of applying for registration, applying for incorporation, members will specify how much money they are contributing towards the assets of the company. Now, the amount of money they specified as what they are prepared to contribute towards the assets of the company is also the amount of money that they have guaranteed the debts of the company, that should there be indebtedness of the company and the company is being wound up, okay, we are prepared to help. How much are you prepared to help? I'm prepared to help to the extent of the amount which I undertook to pay at the time that the company was being incorporated or being formed, as it were. And of course, where there is a breach of this provision, meaning that you do not stick to what the person undertook at the time of forming the company, that he or she will contribute, and you let the person pay less or any other thing, directors or members who are aware or cognizant will also have to be sanctioned personally. So that is another instance of lifting the veil, but we'll come back to the general topic of lifting the veil. So have we understood these types before we come to look at the formation and the rest? Now, I would like us to jump to external companies. We'll go to external companies and then we'll come back. If there is any question, just put up your hand. Okay, yes, Godfred. Godfred?
Good evening, my lord.
Good evening.
Yes, please. My question is in respect of unlimited company. In your explanation, you mentioned that one of the reasons why an individual may choose to register as an unlimited company is that the individual will have peace of mind in respect of reporting. So I would like you to clarify a little bit for me as to whether they don't have to report at all, or I'll appreciate it if you can clarify. And question about, I don't know if I can ask another one before.
Oh, sure, go ahead.
Okay. The second question has to do with the company limited by guarantee. For the amount that they undertake to pay when the company goes insolvent, is there any lower limit for it? Or I can choose to undertake to pay 10 cedi or 20 cedi? Is there any lower limit, please?
No, there's no.
Thank you.
There's no lower limit for the amount that you have undertaken, except that if you are lucky and the debts available to be dealt with is less than all that everybody put together and to contribute, in which case the share will be pro-rated, or they'll be like pro-rata to be shared evenly in proportion to all the ratios, as it were. But it cannot be less. Again, for unlimited company, it will usually be used, for those ventures, as I said, like professionals. Professionals, the requirements, the requirements are relatively, because you have what do you call a bit of like a privacy, so to speak, a bit of a privacy, so to speak, and you don't have public involved. So usually you get maybe like a professionals who just want to enjoy the privileges of incorporation, and they go for that instead of having incorporated private partners. Because mind you, one person can incorporate a company. One person cannot incorporate incorporated private partnership. You want to incorporate incorporated private partnership, you need at least two. But the company, one person can even incorporate it. So if you still want to benefit from some of the trappings of being a corporate body, and maybe for carrying out your professional undertaking or some other things like that, you use that vehicle, as it were. But as we discuss the details of aspects of running the company, some of these distinctions become more concrete to you. But at this stage, we are just trying to use the broad brush approach to explain what the various types of typology are. But as I said, we'll come back to this. So I wanted us to look at the external companies before we move on. So if you jump to the first schedule, section 383, which is about like definition section, the first schedule, it will tell you that a external company has a meaning assigned to it by section 329 So let's go to section 329. Section 329. Section 329. Good. So notice, like, as we said, the whole chapter 5 applies to a external company. So if you look at section 329, it makes the point that section 330 to 342 apply to a external company as defined in this section. So what is external company then? What is an external company? An external company is a body corporate formed outside the Republic, that is formed outside Ghana, which has an established place of business in the country. So it was formed or registered and incorporated outside Ghana, but it has a place of business in what? Established place of business in Ghana. And when we say established place of business, it's a term of art. What does it mean? According to section 3293, the expression established place of business means a branch, management, share, transfer, or registration of a factory, mine, or any other fixed place of business, but does not include an agency unless the agent has and habitually exercises a general authority to negotiate and conclude contracts on behalf of the body corporate, or maintains a stock of merchandise belonging to that body corporate, from which the agent regularly fills orders on behalf of the body corporate. So we are be given various permutations or what count as having established place of business. So if, for example, we have like a company which has like a mine or which has a factory in Ghana, it was registered outside Ghana but has a factory in Ghana, that is established place of business, and that will make it an external company, as it were. But where there's an agency arrangement and somebody serves as an agent, unless, as we have just seen, the agent has extensive powers to be able to conclude contract on behalf of that company which is incorporated overseas. Otherwise, that agency per se will not be treated as being a form of letting that external company have an established place of business in Ghana. So let us keep that in mind. We will go back and discuss, but before we come back later to chapter 5, I would like you to read the rest of the provision between 330 to 342, but we'll go back and discuss our formation and incorporation of company. So have we understood what we have said so that we move on to discuss the formalities of incorporation? Okay, then we move on. So we want to discuss formation and registration of companies, having already understood the various types of companies that may exist under our law. So all the reading lists are provided, the cases which I have listed. When I send these slides, so you are supposed to read all of them and brief them, okay? Good. So formation and registration of companies, the right to form a company. As we have noted not too long ago, every person has the right to work, has the right to earn a living. And for that matter, Section 6 also provides that one or more persons may form an incorporated company. So one person, so if you look at Section 6, one or more persons may form an incorporated company. So one is enough. And mind you, last time I asked you to read the case of Solomon and Solomon, and I want to believe that you're good students, you went to read it again. You notice that under the old English legislation, the Joint Stock Companies Act, it was a requirement that to form a company, you needed, I think, 7 members. But that aspect of the law has undergone further development. And in our part of the world, our law says that one person can even form a company. So let us take note of that. And the question arises, at what stage or can a person actually apply for incorporation of a company? Well, if we look at Section 12 of Act 992, a person of 18 years and above qualifies to apply for incorporation. And this is pertinent. If we look at the repeal at 179, it used to be the law that if you were less than 21 years, you were considered as an infant, and for which reason you lack capacity. But under the new Act 992, if we even go to the first schedule, we try and look up the definition of who an infant is. If you look at, and if we go to page 305, which is part of Schedule 1, we'll be told that infant means a natural person under the age of 18 years or any other age that is declared by enactment to be of full age for legal purposes. So unlike the old regime, which used to say that an infant is someone below the age of 21, now it has reduced the threshold to 18. And for that matter, if you're even 18, in terms of Section 12, you can apply to have an incorporated company registered. So let us keep that in mind. And we have already discussed Section 3 not too long ago, so you know belabor the points. So what are the formalities which a person must comply with before he or she can get a company incorporated? I think I see some chat. Let me see what is there. If there are some questions, then we move on. Oh, is there? Are there any chats? Let's see. Oh, there's nothing. And then there's nothing there. Okay. So, a person who wishes to make or who wishes to have an incorporated company in Ghana must apply to the registrar of companies by following the procedure prescribed under Act 992 with or without proposed constitution. In other words, you can draft your constitution and take it to the registrar of companies that you should be held to have a company registered, but you like your company to have your own tailor-made constitution. Or you can just go with nothing and just simply say that you want to incorporate a company. This is the name that you have. And beyond that, you don't have any other constitution. So that is also permissible. So if you look at Section 13, subsection 5 of Act 992, it reinforces this point that I have just made, that the application for incorporation may be effected by A, delivery of the completed application form, or B, delivery of completed application form accompanied with a proposed constitution. So you complete a form and you have the liberty to take your proposed constitution or just go like that. So that is the point that we are trying to make. And the form which you are supposed to complete will require you to provide the following information as adumbrated in section 13.2, the name of the company, and then when it comes to the name of the companies, we have rules. We'll discuss section 21 very soon, certain surfaces, ending of the names, LTD, PLC, LG, and all that. We'll come and talk about that in the course of time. Then, the form you complete, you need to indicate the type of the proposed company. Is it going to be a company limited by shares? Is it going to be a private company or public company? Is it limited by guarantee? Unlimited company? You must also indicate the nature of the proposed business. If it's a company registered with an object. And let me emphasize that it is not a requirement that you register your company with a stated object. That is to say that maybe we are registering a company to do construction business, to do, what do you call the road? I mean, I don't want to say, mining or galamsey, because as we know, those who engage in it have become so evil that they will put their quest for money over and above the health and safety of present generation and future generation. So I don't want to talk about that. But you want to register a company, maybe to provide IT services, for financial institution and so on. So that is example of the nature of the proposed business. It is not a requirement that you must necessarily disclose one. But if you want, the law permits you to disclose it. In the past, it was a big thing, especially where we have the so-called doctrine of Travaris and all that. It was a big thing for you to state the object, to state the nature of the business the company is being registered to do. And if the directors decided to go into transactions outside the scope or the remit of that, there could be consequences. But now, the rule has been relaxed, and those who are incorporating company have been given the liberty to disclose or not disclose, as it were. Of course, the address of the proposed registered office and place of business of the company in the Republic. So the company must have registered office and then the principal place of business in Ghana, telephone number, postal, email, digital address. All these should be provided. All these should be provided. And of course, the email address and website of the company should also be provided if there's one available. Then the particulars of the subscribers. Particulars of subscribers should also be provided. So someone may ask a question, who is a subscriber in this particular sense? Now, if you talk about subscriber, if you look at the first schedule, right, go to page 308. A subscriber in relation to body corporate means a person who applies for incorporation of a company. So a person who is applying for incorporation or registration of a company is technically known as a subscriber. So let us keep that in mind. So particulars of the subscribers, including their date and place of birth, their names, present and former names, residential, occupational, the various addresses. And of course, now that we have a Ghana card, all those things will have to be provided. And also particulars of directors of the proposed company. If you are registering a company, the company must have board of directors. So who are going to be like the first directors? Their names should be provided and their details, postal address, email address, telephone, and all that. All these should be provided. Now there's another development that a statutory declaration should be made by each of the proposed directors. And the statutory declaration, I hope you know what the statutory declaration is. Okay, if you don't know, there is a law which is called the Statutory Declaration Act. And the Statutory Declaration Act permits any person to make a solemn statement under oath that what the person is saying is true to the best of the person's knowledge and belief. Now, where it turns out to be false, we can demonstrate that when you made those statements, you didn't honestly believe that they were true. That is what they call perjury, isn't it? You having taken oath and having lied under the oath. So that is perjury, so to speak, and that could visit criminal consequences upon you. So that is a statutory declaration. So as part of the application for incorporation, applying for registration of your company, the proposed directors, those who are being suggested to be like the first directors, they will have to make a statutory declaration. And when they made a statutory declaration, they are making a solemn statement under oath that within 5 years, the preceding 5 years, none of them has been charged with or convicted of a criminal offense involving fraud or dishonesty. Now, if you look at the recent case of Derek Edu-Gyamfi against the Attorney General, the Supreme Court has said that provisions of the Companies Act, which says that a person who has been charged with a criminal offense is disqualified from being a director, is unconstitutional because of Article 19 of the Constitution that you are presumed innocent until proven guilty. So if a person is charged with an offense, the person has not been proven to be guilty. And for that matter, that could not disqualify the person from being a director. So let us keep that in mind. So now the important thing is that your declaration will say that within 5 years before making the declaration, you've not been convicted, not charged, you've not been convicted of criminal offense involving fraud or dishonesty. You've not been convicted of criminal offense relating to promotion, incorporation, or management of a company, and you've not been declared insolvent. Or if you have been declared insolvent, you are supposed to provide the date of when you were declared insolvent. The application must also have written consent of each of the proposed directors. Because later on, when we are learning directors, you notice that you cannot appoint a person a director unless the person has consented in writing. Because being a director has got enormous responsibilities associated with it. And as we learn more about corporate governance in the course of this course, you come to appreciate the enormity of the role of directorship. The application must also have particulars of proposed company secretary. So now it is mandatory for a company to have a company secretary. So that person's details should be provided. And again, you must have particulars of the proposed auditors. Every company must have an auditor. You must also provide particulars of the subscribers. As we have said, the subscribers are those who are doing, if you like, the legwork, submitting the application for the incorporation and doing all the necessary completion of the papers and all that. Also, if you have beneficial owner, in other words, if you have a person who is the rare owner of shares, right, in the company, despite the fact that he himself is not going to be registered as a shareholder. Now, information of the beneficial owners must be provided. And of course, this one is a new development and is part of the effort to fight corruption and also money laundering, so that you don't get the politicians or money launderers who may just divert money into companies to acquire shares. And then there will be like the campaigns behind. But those whose names are in the company books as being the shareholders may just be, if you like, just errand boys, not having the rare beneficial interest. So now the law is that you must disclose those who are the beneficial owners of the shares in the proposed company as it will, including their details, everything about them. Even if they are giving a loan to the company, yes, you want to know the details of the arrangement, how it came about and all that. Again, if a company is a company which is limited by shares or a company which has shares, then it is required that the amount of proposed stated capital as defined in section 68 should be stated. The number of authorized shares of the company for each class should be stated. Later on, when we are learning about shares, you notice that we have different classes of shares. A class of share has got the unique bundle of rights and duties for holders of that class, which are not available to other shareholders. So we'll discuss that. Then if it is a company limited by guarantee, then you must also indicate the specified amount up to which a member undertakes to contribute to the assets of the company, as we'll be discussing. Now, as we have noted in section 4, that the Companies Act does not abrogate or does not render inapplicable legislation relating to companies formed for special purposes. If you have a company formed for special purposes, such as maybe like banking or insurance and so on, then in addition to all that we have talked about, you still need to comply with other registration requirements in those special legislation. Let us keep that in mind. Now, let me find out from you, if you have done only some of the things which you have talked about, you haven't done the rest, will it be enough for the register of companies to say that, yes, we are registering you when you have not complied with everything? Or you must comply with everything before you can be registered? What do you think? What do you think? Must you comply with everything, or just comply with some should be enough for you to be registered? Okay, Elizabeth said must comply with everything. Okay. Now there is option to apply for incorporation with the proposed constitution, as we have discussed not too long ago. That unlike the repealed at 179, there's more flexibility now. You can have your full drafted constitution. You take it so long as it is compatible with provisions of the Companies Act. It will be accepted and same will be registered. So as we have indicated, this is not mandatory. It is optional for you to have your own constitution, as it were. So where you have opted for a constitution, then it will have to be signed by the subscribers for shares of the company. You have to indicate the name of the subscriber, the number of shares each subscriber is taking, the amount of money which is supposed to be paid for the shares. All these will be indicated. So look at section 13, subsection 3 and 4 of Act 992. Now, the Registrar of Companies has the power to decline an application for incorporation. If you submit application for incorporation, you can say that it's not going to register your company. Of course, being a discretionary power, as we know, under the 1992 Constitution, Article 296, I think, which has the framework on discretionary power. Is it 296? Yeah, 296, which has the framework on discretionary power. If the Registrar of Companies, for example, has decided not to register you, you can go to High Court and invoke judicial review procedure so that the decision may be quashed, as it were, by certiorari. So question may arise, under what circumstance may the registrar refuse to register a company when application has been made for incorporation? Where the objects are unlawful, then you can refuse it. And you can look at the case of R against Registrar of Companies, ex parte Bowen. And in that case, the Chief Justice, Lord Reading, held that the English Registrar of Companies was wrong, refusing to register and incorporate a proposed company because the name of the proposed company, the United Dental Service, was not offensive of any statute. So what the takeaway is that where the name of the company you propose, for example, is offensive, that is a legitimate ground for the Registrar of Company to say no, that I'm not going to register you unless we bring a new name or you change the name. Or maybe where the name you have proposed is already taken by another company, the registrar can say that no, this name is not available, so we cannot give it to you. So these are some of the legitimate reasons for which the Registrar of Companies can actually refuse. Or where the proposed objects, what the company seeks to do is something unlawful or something immoral, something contrary to public policy. For example, in R against Registrar of Joint Stock Companies, ex parte Moore, the registrar refused to register a company which was formed to sell tickets in an Irish lottery. And eventually, when the challenge of the registrar decision go to the English Court of Appeal. The English Court of Appeal held that the lottery, as at the time, was illegal in England. It's no longer the case now. Now lottery is legal. It was illegal in England, and for that matter, his refusal was right, because the object the company was going to do was illegal. Again, if you don't comply with the form and the various steps prescribed in the law, that is also legitimate ground for the registrar to refuse you. And that is why I agree with the person who said that you must comply with all the procedures before you be registered. Again, if any of the proposed directors, for example, is incompetent or disqualified from being a director, as understood under Section 173, later on, which we will be discussing, for example, as having been convicted of offense involving fraud or dishonesty within the last 5 years, or as having been on discharged bankrupt, and so on, then such a person cannot be a director. And if you put down such a person, that will be a legitimate ground for the Register of Company to say no to your application for incorporation. Of course, if you also opted for a constitution, we've said that should be signed by the subscribers and all that. And if it happened that, the subscribers is, for example, less than 18 years or from sound mind, that can be a ground for refusing the application. But again, it is important to remember that the power of the registrar to refuse registration of corporation is not absolute, and it is subject to judicial review powers of the court. We've already quoted Article 296 of the 1992 Constitution, which governs a discretionary power. And then must also have regard to Article 23 on administrative justice, which is part of compendium of the human rights under our Constitution. So, therefore, in the English case of ex parte AG, very interesting case, an incorporation by the registrar was quashed on the grounds of public policy, an application by the Attorney General, because the object of the company was to promote and facilitate prostitution. So somebody had applied to set up a company to engage in business which will advance prostitution and all that. So later on, the Attorney General applied to court, and the court said that the decision by the registrar to incorporate was wrong, and it should be quashed, and it was so quashed. Now, where the registrar is satisfied that all the requirements have been met, then in terms of Section 14, subsection 1 of Act 992, the registrar will proceed to issue what we call the certificate of incorporation. The registrar will certify under a seal that the company is incorporated. And if it's a company limited it's a limited liability company, that the liability of the company is limited. So a document called the certificate of incorporation will be issued. We will take questions before we move on. Okay, we'll have to draw the curtain down here. We'll continue tomorrow, but let me find out